I would like to ask some questions on the record, if I may, while I have your time here.
Oh, no, let me just tell you, you'll have my time. So we're back on the record in 2024 CR 2974, State versus Hector Casanova. All right, Mr. Casanova, here's the thing. And I want you to hear me clearly, right? I am not your attorney. The document that has been given you is a copy of the indictment. I'm not to give you information about your indictment. That's the indictment. That's what we're here for. So any questions that you would have about that indictment, you're going to have to answer those for yourself. Otherwise, the person who will be telling you about what the indictment means and what the numbers are, that will be an attorney. Do you understand?
I do not understand.
What that means is, for example, we can go off the record. I'm giving you a hypothetical. All right. Let's say you needed surgery and you're in the middle of the wilderness, you need surgery, and you tell me and you tell the doctor, guess what? I'm performing this surgery on my own. I don't need you. I'm walking out of the hospital. I'm going to go in the desert. Now, maybe the doctor would try to stop you and do other things. But if you go in that desert by yourself, don't tell the doctor where you are. You take a scalpel out in the desert.
This case is a perfect example of how things can spiral fast in courtroom, even when the original charge isn't what you'd expect. A man pulled over for a traffic issue ends up facing serious consequences, not because of what happened that night alone, but because of what happens after he's released on bond. We're talking about an ignition interlock device, possible alcohol use, and a judge who makes one thing crystal clear. Bond conditions are not suggestions. They're rules. But here's where it gets complicated. The defendant wasn't even charged with DWI, yet he's being treated like alcohol is a central issue. So the big question becomes, are these restrictions fair or is the system overreaching? Stay with us, because what unfolds next raises serious questions about accountability, enforcement, and whether this outcome was truly avoidable. I sent you to go to a test, and now you're testing positive for alcohol. Guess what happens now? He goes with you. Not sure why he has his device on his I don't know, but there's a bond condition, and when you don't live up to the bond condition, there are consequences. Just like anything in life, when you have a criminal case, you have conditions that you have to live by, and when you don't, there are very serious consequences.
I would like to ask some questions on the record, if I may, while I have your time here.
Oh, no, let me just tell you, you'll have my time till 5 o'clock because that's how long we're here. What is going to end up happening is an attorney from managed assigned counsel is going to come down. Do you understand?
I do not understand because I I don't feel like I am needing an attorney because I'm here to represent myself as the flesh and breathing man, Hector Casanova Jr. Um, let's see. Um, all right, so let the let record of the court show that I, Hector Casanova
Just one
Jr.
second.
The accused
Just
in
one
the
stop.
Yes, sorry.
All right, we're on the record. So what did you want the record to reflect?
So let the record of the court show that I, Hector Casanova Jr., the accused in this criminal action, has asked the court to divulge the nature and cause of the accusation upon the authority of the Sixth Amendment, and that this court has failed in its duty to inform me of the nature and cause of this action. Furthermore,
let me
let the
stop
record
you.
also show.
Mr. Casanova, let me ask you a question. Have you been given a copy of the indictment?
I believe so, yeah.
All right, so let the record reflect that Mr. Casanova has been given the copy of the indictment, and the copy of the indictment, it tells him what he is charged with. You may continue.
Now, these charges, are they civil? Is this a civil charge or a criminal charge?
All right, that is something that if you had an attorney to represent you, they would be able to tell you. What the court can tell you is that you are in a felony court and this is a criminal court.
Okay. So, this being a criminal, let the record of the court show that the action against me is criminal action. My following question would be, the Constitution.
Right out of the gate, the judge is laying down a fundamental legal principle. Bond conditions are binding. It doesn't matter if you agree with them, understand them, or even think they're fair. Once you're out on bond, compliance is mandatory. What's especially interesting here is that the judge admits uncertainty about why the device was required in the first place. That's a major detail. Typically, ignition interlock devices are tied to DWI-related offenses. Yet this defendant was charged with fleeing, not intoxication. So now we got a situation where enforcement is strict, but the foundation of that restriction is being questioned. That tension is going to drive everything that follows. Let me ask you, should someone be penalized as harshly for violating a condition that might not have been necessary to begin with? Mr. Steyer, you're on bond for fleeing a police officer. The report is that your device is in lockout, and it's been in lockout since 24. Can we address the need for this bond condition? I don't remember the case. So, let's do PC real quick. Yes, and then we'll go from there. So, on August 17th, 2024, at approximately 2 a.m., the officers observed a vehicle with a defective tail lamp and tried to initiate a traffic stop. The vehicle had ample opportunities to stop at multiple well-lit parking lots, but drove 46 miles to the final stop location. The defendant had red, glossy eyes and continuously apologized. The vehicle was running, and the officers also observed a slight odor of an alcoholic beverage from the defendant's body. The defendant had slurred speech and repeated, "I'm just trying to go home. I came from work." But the defendant could not specify his place of work. The defendant, clear his throat, denied drinking alcohol, and the officers found an open container of Color XO brandy container under the driver's seat and a Taurus pistol under the passenger seat, without a holster.
The Constitution grants this court two types of criminal jurisdiction. Criminal jurisdiction under the common law and criminal jurisdiction under the admiralty or military tribunal. In which of these two jurisdictions does this court intend to try me?
All right, so this is what is going to happen, Mr. Casanova. Someone from Managed Assigned Counsel is going to come over and you can speak with them or not speak with them. But the questions that you are asking the court are not, some of them are not in any shape, form, or fashion related to the fact that you're in a criminal district court. Do you understand?
I do not understand.
Okay.
But I don't think you'll be violating your oath of office if you did your duty under the Constitution. I am not seeking legal advice. What I want to know is legal intent.
Mhm.
I have the right to appear as myself to my own person without a licensed attorney. In order to intelligently defend myself, I need to know the jurisdiction this court is operating under.
Mhm.
Let's see. So therefore, will you please answer the question so that way this court is properly identified?
All right, you're in the 187 District Court. It's a criminal court. You're on the 4th floor.
Thank you. This Constitution grants this court two types of criminal jurisdiction. Criminal jurisdiction under the common law and criminal jurisdiction under.
All right, I'm going
admiralty or military
to counsel.
tribunal.
I'm sorry, Mr. Casanova, in the human flesh. I'm going to stop you right there. What is going to end up happening, I want you to hear me clearly. An attorney is coming over for Managed Assigned Counsel, period. That's it. So have a seat. Managed Assigned Counsel will come over. Do you understand? Yes or no?
I do not understand.
All right. Do you understand what it means to take a seat?
I do understand.
All right.
Now, this is where things start to feel contradictory. You're hearing classic indicators of possible intoxication: slurred speech, red, glossy eyes, the odor of alcohol, even an open container in the vehicle. Those are all major red flags. But here's the twist. No DWI charge was filed. No field sobriety test. No formal intoxication investigation. That's not just unusual, it's critical, because now everything happening in court is based on implications rather than formal charges. And that raises a serious issue. If law enforcement didn't think it was strong enough to charge at the time, should it now justify strict bond conditions? Or is the court trying to compensate for what might have been a weak or incomplete investigation? So, What bond conditions were there that their clear as throat alleged to have violated? Let's see. You want to help me out? Sorry. This is Steyer. Yes, please. He doesn't have any previous violations. It's just that the device is a lockout. What device? The ignition device. So, they put an ignition interlock. I guess the magistrate put an ignition interlock on it. Clear as throat, charged with DWI. Yes, on August 28th, I got it. But he allegedly had alcohol in the car. I don't know how. I mean, begs the question, why did they charge him?
So take a seat. Thank you. All right, so Mr. Casanova, Mr. Bach is going to be your standby counsel. And that's someone that if you have questions, you can ask him legal questions or what you may have.
Thank you for your consideration.
All right.
Uh,
And he informed me you wanted to place something on the record?
yes, for the record, I wanted to make it known that I'm here on special appearance under threat, duress, and coercion.
All right, who threatened or coerced you to come to court?
The county of Texas.
How
State.
so?
Well, if I don't come here, then warrants will be placed, which I will be kidnapped and held hostage, and I do not want that. So that's why I'm here under special appearance to clarify any misunderstandings and to let it be known where I stand on the record.
Okay. Is there anything else?
I said everything that needed to be said.
Okay. All right. So what we're going to do is we're going to recall your case in 1 month. It's going to be a discovery setting. So that's to make sure that you have all the information that the state has concerning your case. Do you understand?
I do understand.
All right, Ms. Ferguson, if I can have a 30-day reset for Mr. Casanova. And after you receive all the discovery, then the next setting is going to be a plea deadline date. The state will tender an offer to you at the next setting. And then I'll give you your plea deadline date and you can accept the state's offer or come to an agreement.
This is the moment where even the judge seems puzzled, and that's rare. If there was enough concern to install an ignition interlock device, why wasn't there a DWI charge to support it? That disconnect matters. Because now, the defense has a legitimate argument. The restriction may not match the actual charge. But at the same time, the prosecution is leaning on the presence of alcohol-related indicators to justify it. So here's the big question for you. Do you think courts should err on the side of caution when public safety is involved, even if the original charge doesn't fully support it? Or should every condition be strictly tied to what was officially proven? It should have been aware that officers are officers. We're supposed to allow them to do their job. And when their job doesn't rise to what folk think it should be, then all of a sudden they didn't do their job right. We want to talk to the supervisor. The officer didn't charge him. He didn't charge him. So he only got charged with fleeing. I don't understand why he's got this device on. Did they do a field sobriety test? They did not, Your Honor. There was no DWI investigation done at the scene. Was there any indication that he was intoxicated? Yes, he had slurred speech, red glossy eyes, and an odor alcoholic beverage. Yes.
Agreement or not, if you're unable to come to an agreement at that time, it'll be scheduled for jury trial.
Thank you, Ms. Boyd.
You're welcome. Any other questions?
I have no further questions.
All right, so Ms. Ferguson is going to give me a date and then you'll sign it. Mr. Bach will sign it to signify when you're to come back. All right.
I appreciate your time.
All right, you're welcome. And thank you for dressing appropriately for court. What date, Ms. Ferguson? All right, so we'll be back on July 29th. All right, once you sign the reset form, you'll be excused. Yes.
If something were to come up and I need to maybe reschedule that date, is that a possible thing to
You'll
come
need-
up ahead of time?
You'll need to speak to the court coordinator and they will let you know. I will tell you the rescheduling of cases. Are you in the hospital? You're not in the hospital, you need to be here.
Okay,
You understand?
so pretty much no excuse, be here.
Yes. All right, thank you.
Thank you.
All right, I think that's our last case for the day. Is that correct? All right, thank you for coming over, Mr. Bach.
Yes, Judge.
All right.
How do y'all do this?
Charles. BUN.
I was just about to ask you
Yes.
This case ultimately comes down to one powerful lesson. In the courtroom, compliance is everything. Even though the original situation raised questions, no DWI charge, a possibly flawed investigation, and uncertainty about the ignition interlock device, none of that mattered in the end. What mattered was behavior while on bond. The positive alcohol test became the factor, leading to bond revocation and a significantly increased bail. It's a clear example of how courts prioritize public safety and strict adherence to conditions above all else. But it also leaves us with an important question. Should there be more scrutiny on how those conditions are assigned in the first place?